Thank you.
For those arguments. I'm asking the jurors want to break. My instructions, I don't have an accurate estimate, but probably about 25 minutes. And then you go into the jury room to begin deliberations. Anybody request a break at this time? Don't hesitate if you want one. Hearing none, then I will proceed with instructions. As I told you, members of the jury, all of the evidence has been presented. It is now your duty to decide from this evidence what the facts are. You must then apply the law which I'm about to give you to those facts. It is absolutely necessary that you understand and apply the law as I give it to you, and not as you think it is or as you might like it to be. This is important because justice requires that everyone tried for the same crime be treated in the same way and have the same law applied in each such case. As you will see, I will give you my instructions orally and parts thereof in writing as well. The fact that part of the instructions shall be given orally and in writing and other parts only orally is of no significance. That is, you should give all of my instructions equal consideration, regardless of the format in which presented to you. No more or no less weight should be given to any instruction based on whether given orally or orally and in writing. My complete instructions to you comprise the law that you are to apply to the facts as you find them to be. As you will recall, in my discretion I have allowed you to take notes in this case. In accordance with my earlier instructions to you, I instruct you further as follows. In your deliberations, you may use your notes as a reference to aid you or assist you in refreshing your memory as to the evidence presented to you in this trial. I caution you, however, and remind you not to give your notes or the notes of any other jurors undue significance in your deliberations. You are to consider all of the evidence presented to you, whether or not you or any other jurors made notes as to some or all of the evidence that was presented. Remember that neither your notes nor the notes of any other jurors are to be considered as evidence in this case. Notes of a juror are not an official transcript or a record of evidence in the case. Your notes are only to assist your memory, and the notes of any juror or jurors are not entitled to any greater weight than the notes of other jurors or the individual recollections of other jurors, whether recorded or unrecorded by note-taking. To these charges, the defendants have entered pleas of not guilty. The fact that they have been charged is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, he or she is not required to prove his or her innocence, but is presumed to be innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense, arising out of some or all of the evidence that has been presented, or lack or insufficiency of the evidence as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. You are the sole judges of the credibility, that is, the believability of each witness. You must decide for yourselves whether to believe the testimony of any witness. You may believe all or any part or none of what a witness has said on the stand. In determining whether to believe any witness, you should apply the same test of truthfulness which you apply in your everyday affairs. These tests may include, among other things, the opportunity of the witness to see, hear, know, or remember the facts or occurrences about which the witness testified, the manner and appearance of the witness, any interest, bias, or prejudice the witness may have, the apparent understanding and fairness of the witness, whether the testimony is reasonable, and whether the testimony is consistent with other believable evidence in the case. You are the sole judges of the weight to be given any evidence. This means if you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all other believable evidence in the case. The defendants in this case have not testified. The law gives them this privilege. This same law also assures them that their decision not to testify creates no presumption against them. Therefore, the silence of the defendants is not to influence your decision in any way. There are two types of evidence from which you may find the truth as to the facts of a case: direct and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain or group of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all the evidence in the case. After weighing all the evidence, if you're not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. And when I say defendant, of course, it's applicable to both defendants. You may find that a witness is interested in the outcome of this trial. In deciding whether or not to believe such a witness, you may take the witness's interest into account. If after doing so you believe the testimony in whole or in part, you should treat what you believe the same as any other believable evidence. As you will recall, certain photographs and diagrams were introduced into evidence in this case for the purpose of illustrating and explaining the testimony of witnesses. These exhibits may not be considered by you for any other purpose. In this case, you've heard evidence from a witness who has testified as an expert witness. An expert witness is permitted to testify in the form of an opinion in a field where the witness purports to have specialized skill or knowledge. As I have instructed you, you are the sole judges of the credibility of each witness and the weight to be given to the testimony of each witness. In making this determination as to the testimony of an expert witness, you should consider, in addition to the other tests of credibility and weight, the witness's training, qualifications, and experience or lack thereof, the reasons, if any, given for the opinion, whether the opinion is supported by facts that you find from the evidence, whether the opinion is reasonable, and whether it is consistent with other believable evidence in the case. You should consider the opinion of an expert witness, but you're not bound by it. In other words, you're not required to accept an expert witness's opinion to the exclusion of the facts and circumstances disclosed by other testimony. When evidence has been received tending to show that at an earlier time a witness made a statement which may be consistent with or may conflict with his or her testimony at this trial, you must not consider such earlier statement as evidence of the truth of what was said at that earlier time because it was not made under oath at this trial. If you believe that such earlier statement was made and that it is consistent with or does conflict with the testimony of the witness at this trial, then you may consider this, together with all other facts and circumstances, bearing upon the witness's truthfulness in deciding whether you believe or disbelieve the witness's testimony at this trial. Mr. Sheriff, if you would hand these out, please. What's being handed to you are my instructions that are in writing that you will take with you to the jury room for your use in your deliberations. You may make notes on these if you desire to do so. At the end of the case, they will not be collected. You'll be able to deal with them as you desire. They're just for your reference. You should have 5 printed pages numbered in the upper right-hand corner. If you don't have those in that order as we go through it, let me know at that time. The defendant, Kimberly Hunt Matthews, and the defendant, Charles Joseph Matthews, have each been charged with 4 counts of aiding and abetting a person under the age of 21 to possess and or consume an alcoholic beverage, to wit, wine. As to each of the respective defendants, and as to each of the respective counts of aiding and abetting a person under the age of 21 to possess and or consume an alcoholic beverage, for you to find a defendant guilty of an offense of aiding and abetting a person under the age of 21 to possess and or consume an alcoholic beverage, the state must prove 4 things beyond a reasonable doubt. First, that a person under the age of 21 possessed and or consumed an alcoholic beverage, to wit, wine. Second, that the defendant knowingly encouraged and or aided that underage person to possess and or consume that alcoholic beverage. Third, that the defendant knew or had reason to know that the person was under the age of 21 at that time. And fourth, that the defendant was over the age of 21 at that time. In file number 14 CRS 218541, count 1, as to the defendant Kimberly Hunt Matthews. If you find from the evidence beyond a reasonable doubt that on or about the alleged date that Natalie Freeman was under the age of 21 and that Natalie Freeman possessed and or consumed an alcoholic beverage, to wit wine, and that the defendant knowingly encouraged and or aided that underage person to possess and or consume an alcoholic beverage, to wit wine, and that the defendant knew or had reason to know that Natalie Freeman was under the age of 21 at that time, and that the defendant was over 21 years of age, it will be your duty to return a verdict of guilty. If you do not so find to have a reasonable doubt as to one or more of these things, it will be your duty to return a verdict of not guilty. In file number 14 CRS 218541, count 2, as to the defendant Kimberly Hunt Matthews, if you find from the evidence beyond a reasonable doubt that on or about the alleged date that Jonathan Taylor was under the age of 21 and that Jonathan Taylor possessed and or consumed an alcoholic beverage, to wit wine, and that the defendant knowingly encouraged and or aided that underage person to possess and or consume an alcoholic beverage, to wit wine, and that the defendant knew or had reason to know that Jonathan Taylor was under the age of 21 at the time, and that the defendant was over 21 years of age, it will be your duty to return a verdict of guilty. If you do not so find to have a reasonable doubt as to one or more of these things, it will be your duty to return a verdict of not guilty. In file number 14 CRS 218541, count 3, as to the defendant Kimberly Hunt Matthews, if you find from the evidence beyond a reasonable doubt that on or about the alleged date that Thomas Blake Matthews was under the age of 21 and that Thomas Blake Matthews possessed and or consumed an alcoholic beverage, to wit wine, and that the defendant knowingly encouraged and or aided that underage person to possess and or consume an alcoholic beverage, to wit wine, and that the defendant knew or had reason to know that Thomas Blake Matthews was under the age of 21 at the time, and that the defendant was over 21 years of age, it will be your duty to return a verdict of guilty. If you do not so find to have a reasonable doubt as to one or more of these things, it will be your duty to return a verdict of not guilty. In file number 14 CRS 218541, count 4, as to the defendant Kimberly Hunt Matthews, if you find from the evidence beyond a reasonable doubt that on or about the alleged date that Mary Ann Ergish was under the age of 21 and that Mary Ann Ergish possessed and or consumed an alcoholic beverage, to wit wine, and that the defendant knowingly encouraged and or aided that underage person to possess and or consume an alcoholic beverage, to wit wine, and that the defendant knew or had reason to know that Mary Ann Ergish was under the age of 21 at the time, and that the defendant was over 21 years of age, it would be your duty to return a verdict of guilty. If you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. In file number 14 CRS 218542, count 1, as to the defendant Charles Joseph Matthews, if you find from the evidence beyond a reasonable doubt that on or about the alleged date that Natalie Freeman was under the age of 21 and that Natalie Freeman possessed and or consumed an alcoholic beverage, to wit wine, and that the defendant knowingly encouraged and or aided that underage person to possess and or consume an alcoholic beverage, to wit wine, and that the defendant knew or had reason to know that Natalie Freeman was under the age of 21 at the time, and that the defendant was over 21 years of age, it would be your duty to return a verdict of guilty. If you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. In file number 14 CRS 218542, count 2, as to the defendant Charles Joseph Matthews, if you find from the evidence beyond a reasonable doubt that on or about the alleged date that Jonathan Taylor was under the age of 21 and that Jonathan Taylor possessed and or consumed an alcoholic beverage, to wit wine, and that the defendant knowingly encouraged and or aided that underage person to possess and or consume an alcoholic beverage, to wit wine, and that the defendant knew or had reason to know that Jonathan Taylor was under the age of 21 at the time, and that the defendant was over 21 years of age, it will be your duty to return a verdict of guilty. If you do not so find to have a reasonable doubt as to one or more of these things, it will be your duty to return a verdict of not guilty. In file number 14 CRS 218542, count 3, as to the defendant, Charles Joseph Matthews, if you find from the evidence beyond a reasonable doubt that on or about the alleged date that Thomas Blake Matthews was under the age of 21, and that Thomas Blake Matthews possessed and or consumed an alcoholic beverage, to wit wine, and that the defendant knowingly encouraged and or aided that underage person to possess and or consume an alcoholic beverage, to wit wine, and that the defendant knew or had reason to know that Thomas Blake Matthews was under the age of 21 at the time, and that the defendant was over 21 years of age, it will be your duty to return a verdict of guilty. If you do not so find or have a reasonable doubt as to one or more of these things, it will be your duty to return a verdict of not guilty. In file number 14 CRS 218542, count 4, as to the defendant, Charles Joseph Matthews, if you find from the evidence beyond a reasonable doubt that on or about the alleged date that Mary Ann Ergish was under the age of 21, and that Mary Ann Ergish possessed and or consumed an alcoholic beverage, to wit wine, and that the defendant knowingly encouraged and or aided that underage person to possess and or consume an alcoholic beverage, to wit wine, and that the defendant knew or had reason to know that Mary Ann Ergish was under the age of 21 at the time, and that the defendant was over 21 years of age, it will be your duty to return a verdict of guilty. If you do not so find or have a reasonable doubt as to one or more of these things, it will be your duty to return a verdict of not guilty. And members of the jury, you've heard the evidence, you've heard the arguments of the lawyers, and as I said to you previously, if your recollection of the evidence differs from that of the lawyers, you are to rely solely upon your recollection. It is your duty to remember all of the evidence, whether it's been called to your attention or not. You should consider all of the evidence, arguments, contentions, and positions urged upon you by the lawyers, and any other contention that arises from the evidence. And in using your common sense, you must determine the truth in this case. As the presiding judge, I am required by law to be impartial. You should not mistakenly infer that I have implied any of the evidence should be believed or disbelieved, that a fact has or has not been proved, or as to what your findings ought to be. Instead, you alone are to find the facts and to render a verdict reflecting the truth as you find it to be. You may not return a verdict until all 12 jurors agree unanimously as to what your decision may be. You may not render a verdict by a majority vote. At this time, it appears to the court that the original 12 jurors are able to proceed. So I'm asking now and directing the alternate jurors step out of the jury box. But let me ask you before you go, do you have any belongings in the jury room? Do you have any personal belongings, anything in the jury room? All right. Please step out. If you can slip over a little bit, sir, I'm going to have them sit right there. If y'all will step out and sit on that front row, I'll come back to you with instructions shortly. Please watch your step. The two alternate jurors have stepped out of the jury box. Let's see, I've been saying to you since Monday not to discuss or communicate about this case with anyone until I say to begin deliberations. The instruction to begin deliberations will be when this envelope with the verdict forms is handed to you in the jury room. It's not what you already have. These are the verdict forms. They will be in this envelope. They will come to you shortly after you go into the jury room. So the first thing to do is to select one of your members to serve as your foreperson to lead you in your deliberations. It is not necessary that you notify me of the selection at the time you make that selection. And when the verdict forms are handed to you in the jury room, that is your instruction to go into deliberations. Express your opinions about the case, listen to and consider the opinions of your fellow jurors about the case, all in an attempt to arrive at unanimous verdicts as to the 8 offenses submitted to you. When you have reached unanimous verdicts as to all 8 offenses, have your foreperson mark the verdict forms in accordance with your jury verdicts, sign and date those forms, knock on the door to the jury room. The sheriff will bring you back into the courtroom to pronounce your verdicts. It is my practice to stay on a regular schedule while jurors are deliberating with regard to starting court in the morning, taking a lunch break, and stopping at the end of the day. But I won't bring you out for a break mid-morning if you're deliberating, or mid-afternoon if you're deliberating, like we do during the testimony phase of the trial. I let you decide if you want a break. Now, what that means is you may have a break. You just decide if and when you want one. And please recognize the request from any juror for a break. But don't just leave. Let the sheriff know. I'll bring you back into the courtroom to pronounce you in a recess. Remember, the only time and place you may communicate about this case, even among yourselves, and that includes deliberations, is when you're in the jury room, when all 12 of you are present, and I have instructed you to deliberate. So, meaning if you take a break, and I don't remember to tell you this, when you come back after the break, until I say resume deliberations, do not resume deliberations. Whether you take a break together, whether you reconvene together, until I say to resume deliberations. So again, first thing is to select a foreperson. Then when the verdict form is handed to you, that is your instruction to go into deliberations. When you've reached unanimous verdicts and are ready to report, please have your foreperson or somebody knock on the door. The sheriff will bring you back into the courtroom to pronounce your verdicts. Again, when you've reached unanimous decisions as to the verdicts, have your foreperson mark it, date it, sign it, come into the courtroom to pronounce your verdicts. Please retire in accordance with those instructions. Sheriff will direct you out right here. We're in the absence of the jury prior to deliberations beginning. To begin with, are there any objections to that charge or requests for corrections or additions from the state?
Not on behalf of the state, I don't think.
Your Honor, I think based on my previous motion, I do need to enter an objection to the instructions as they were given with regards to the and/or ambiguity issue.
So no additional objections, but that's an objection. It's noted and preserved.
Thank you.
With that said, are you satisfied with the form and content of the verdict forms consistent with your earlier objections?
Yes, sir.
And you as well?
Yes, sir.
Mr. Sheriff, please deliver the verdict forms to the jury. As always, do not enter the jury room. There would be no procedural purpose for retaining alternates. Is that correct?
No, sir.
Is that correct?
That is correct, yes. No need to retain them.
To the alternates, this completes your jury service. You are welcome to stay with us. All of those restrictions I put on you are lifted. It's entirely up to you whether you discuss this case with anyone. It's entirely up to you whether you'd like to stay. You're welcome to stay with us, but you're no longer part of the jury. The restrictions are still on the jurors, so they will not be communicating with you about this case. If you need a certificate to verify your attendance for jury duty, you may get one from the jury clerk. And as before, I thank you for your service on behalf of the people of Wake County and state of North Carolina. You're not eligible to serve again for a period of 2 years. So if you get a notice within 2 years, it'll be a duplication error. Call the clerk's office, save yourself a trip down here. If you're going to leave, please turn in your badge as you go. But before you go, if you're going, do you have any questions? All right. Again, thank you for your service, and you're excused. If you'd like to leave, you may do so at this time. If you'd like to stay right there. We're going to be at ease for just a few minutes, unless there's something else for the court to deal with right now.
No, Your Honor.
All right. Be at ease, close at hand, expecting to hear from the jury with requests, questions, and verdicts. Court stands at ease.